Hello, everyone. Greetings. We are just about ready to get started digging into meal and rest breaks. We have Tom Revnew from Littler Law. He is going to provide us some background information and things that our companies should be doing to prepare for this new law in January. Tom says he has probably about 15 minutes to break down the law, and then we'll open it up for questions. You can start putting questions in the chat if you have questions, and then Tom will look at those, and then we'll just take everyone on mute or take everyone off mute and allow for conversation that can just, go back and forth after he breaks down the law. So at this point, I'll introduce Tom Revnew and you can get started.
Thanks, Chris. Good morning, everyone. As you know, my name's Tom Revnew with Littler Mendelson, and I've worked in the print industry for quite a few years. Been practicing for a long time. I won't go into how long. But with regard to meal and rest breaks, hopefully everybody at this point knows that the law is changing as of January 1st. And when the law was amended, it was amended during the last legislative session. So during 2025, during the legislative session, the legislature decided that it made sense to change break time laws in Minnesota. And frankly, this change, which is a significant change for the business community, was not on anybody's radar. And the reason it wasn't on anybody's radar is because it's something that nobody thought was going to go anywhere. And at the 11th hour, it was added to the omnibus bill and it eventually passed. And it was a bill that was sponsored by unions, and in particular, unions working in for healthcare facilities that were really pushing this issue. And so when it was ultimately passed, like I said, I don't think anybody realized what it meant. I don't think the Republicans really gave this a lot of thought at the time when it got passed, and it has huge significant issues for the business community. And what I'm going to talk about really hammers home that in Minnesota, we're obviously a very progressive state, but we are now very California-esque, as well as very similar to the state of Washington, because what I'm going to talk about are laws that are comparable to what now exists in California and the state of Washington and a uh, few other states. And so what I thought made sense, just so everybody could wrap their arms around what these changes are, is I would talk about first the rest break law and how it was changed, and then get into the meal break law. So on this slide, you can see how the legislature changed existing law to what the law will look like as of January 1st. So under existing law, up until the end of this year, when it comes to work breaks, the law provides that we must allow each employee adequate time to essentially utilize the nearest convenient restroom. So existing law does not provide how much time you have to provide employees to use the restroom, but rather it says that you have to provide them enough time or adequate time from work to utilize the nearest convenient restroom. As the law will be amended, it provides that you must allow employees at least 15 minutes or enough time to utilize the nearest convenient restroom, whichever is longer, when each 4 consecutive hours of work. So previously, or current law is, you have to allow them adequate time to use a restroom within each 4 hour 4 consecutive hours. As of January 1st, you have to allow them at least 15 minutes or enough time to utilize the nearest convenience restroom, whichever is longer, to use the restroom. And of course, I don't know who's thinking that they're going to have a rest break monitor or restroom monitor. But you can see there's a little bit of ambiguity within the law, which says, hey, you have to provide them the greater of 15 minutes or enough time to utilize the nearest convenient restroom. And I don't think anybody wants to be in the business of determining whether somebody did not need more than 15 minutes to use restroom. So in essence, there's going to be significant changes within your business and within your scheduling with regard to how you permit employees to take restroom breaks or rest breaks in particular. But keep in mind that under this law, the breaks have to be within each 4 consecutive hours. So the break can't be at the end of the 4 hours. The break has to be within that 4 hour segment. And I'll touch on what penalties will be if we don't do this properly. Now, there's another piece that's built into the rest break statute, which essentially provides that nothing in this section prohibits employers and employees from establishing rest breaks different than those provided in the section pursuant to a collective bargaining agreement. So I believe there are some of you that are on this call that may that may have a union that represents your employees. And there's a provision that says you can establish something different from those provided under this law pursuant to a collective bargaining agreement. There's ambiguity with regard to what different means, and there are different provisions within Chapter 177, which deals with the work breaks and the meal breaks. That seems to imply that different may mean that it's greater than what's provided under these statutes. So if you are a employer or a business that is signatory to a collective bargaining agreement, what I would suggest is that you talk with your legal counsel with regard to what is the best way to address your obligations under this law as compared to what your CBA provides for, because I think there is some significant exposure. And oftentimes when I look at collective bargaining agreements, they may provide for nothing on rest breaks or nothing on meal breaks, or they may provide something that is less than the 15 minutes or less than 30 minutes, which I'll talk about momentarily. So the second piece is with regard to mandatory meal breaks. And again, you can see what the law provides currently versus what it will provide as of January 1st. So currently, until January 1st, the law provides that an employer must permit each employee who is working 8 or more consecutive hours sufficient time to eat a meal. As of January 1st, the law provides that an employer must allow an employee who is working for 6 or more consecutive hours a meal break of at least 30 minutes. And I know one of your questions is likely, well, we run 12-hour shifts, and do we have to provide 2 meal periods during a 12-hour shift? And the Department of Labor and Industry has issued guidance, and with regard to that guidance, they've made it clear that no, the law essentially says you have to allow a meal break if they work 6 hours or more. You have to give them that 30-minute break. It does not provide that you have to provide them a meal break for every 6 hours that they work. And again, as I said earlier, with regard to mandatory meal breaks, you have the same language that provides that nothing in the section prohibits employers and employees from establishing meal periods different from those provided in this section pursuant to a collective bargaining agreement. And of course, I'm getting working with a lot of employers that have collective bargaining agreements, and oftentimes their collective bargaining agreements, particularly for somebody who's working an 8-hour shift, does not address meal breaks. And oftentimes it's because the employees just want to work through that 8 hours. They get their, their rest periods, and they want to go home. And by adding a meal break, it adds to the time that they're away from work. And of course, now you have this issue with regard to, well, the law is very clear that we have to provide them with a 30-minute meal break, not sufficient time to eat a meal, which is, there's a huge difference with regard to sufficient time versus providing them with at least 30 minutes. And of course, the significant issue that hopefully is on everybody's radar is if you fail to provide either the rest breaks or you fail to provide the meal breaks, then you're liable for the employee for the meal or rest break that should have been allowed at the employee's regular rate of pay, plus an additional amount as liquidated damages. And so what the state legislature has essentially done is they have created a wage and hour issue for employers that if you fail to provide rest breaks within the 4 consecutive hours worked, or you fail to provide a meal period, if an employee is working at least 6 consecutive hours and that meal break is not provided or it's less than 30 minutes, you now have a wage and hour issue on your end and for that perspective as well. So essentially, you could have claims that the employees were denied their 15-minute break within the 4 consecutive hours, and you could have claims that you denied the employee an opportunity to have a meal break of 30 minutes when they work 6 consecutive hours or more. And so what I have been advising clients is, first and foremost, you have to get a hold of, a handle on how your scheduling works. And two, I think there's a significant education here with regard to educating your managers and your supervisors with regard to now you have significant legal risk if you deny or don't allow employees to take rest breaks within the 4 consecutive hours worked, or you fail to allow them to take the 30-minute meal period as permitted under the law. And the other question that is often raised by businesses when I'm talking to them is, well, what if an employee wants to work through a meal break? What can we do? Can they work through a meal break, and is that permitted? And of course, there are some unpublished decisions that were issued by courts in Minnesota that yes, employees can waive their rights to a meal period or a break period. And of course, Dolly, as many of you probably know, Dolly, the Minnesota Department of Labor and Industry, issued guidance with regard to whether employees can waive their rights, and they have said yes, they can. That's guidance. That's not the force of law. We think employees can waive their rights to a meal as long as you're allowing them to take the meal and they waive it. We think you're going to be fine. Of course, the law is new, and how the courts interpret the law, we don't know. But if you're going to allow employees to waive their meals or waive their breaks, or advice is to make sure that you have forms that the employees sign off on acknowledging that they're either waiving their meal for the day in question, or they're waiving their meal based on the schedule that they're working, giving them the opportunity to revoke that waiver at any point in time. And of course, those forms that employees sign should make it clear that the waiver is a voluntary waiver. As I said, with regard to what about union employees, as I said, there's language built into the statute that essentially says a collective bargaining agreement can create a different entitlement for leaves or for breaks for employees. And of course, from FAQs that were issued by the Department of Labor and Industry, it seems like a collective bargaining agreement could secure flexibility for employees, despite the fact that it is different from the statute, and then it could be considered less favorable. Again, I note that there is a conflict built within the statute, that there is a provision not directly on rest and meal breaks, but dealing with the overall statutory scheme of Chapter 177 that essentially says employers and unions can negotiate something more favorable. So the question becomes, when the statute's referring to something different, does it mean it has to be more favorable? My concern is that the unions may agree to something different, and the question becomes, what about a plaintiff's side wage and hour attorney? What are they going to argue or say with regard to, can you negotiate something different that is less favorable than the statutory scheme work for meals and rest breaks? And that's an open issue. And I've talked about the waivers. And additionally, as I noted, the Minnesota Department of Labor and Industry has issued FAQs on work breaks and rest periods. That's available on their website. I will make these slides available for everyone as well. But again, as I told Chris, I think the devil is in the details with regard to how you address these changes from an operational standpoint. How the law changed it's clear how the law changed for the most part. I think the issue is, how do employers modify their schedules, or how do they ensure that their schedules remain compliant with what the law will provide as of January 1st. So I told Chris I would open it up for questions after about 15 minutes, and we're about 20 minutes into our session here.
Yeah, at this point, I haven't seen anyone send anything in the chat. Oh, well, Carrie asked, what's the difference between allow and permit in this situation?
Yeah, it's a good question. I mean, our view is it's the same, but the legislature did change the language, and we certainly scratch our head wondering what the difference is between allow and permit. But the bottom line is, if you're telling employees that uh, they can take a meal break or they can take a rest period, that is essentially, you're meeting your obligations, right, in allowing them to do so. Yeah, I see one of the questions is, any advice on the frequency of employee waivers each shift once at hire? Great question. Again, as I said, this law is brand new. How it is going to be interpreted or applied in the future, we don't know. The Department of Labor and Industry is still contemplating whether they're going to issue rules, administrative rules, with regard to how the law will be applied on a going forward basis. They have the authority to issue administrative rules to provide that guidance. So currently, again, we're basing our analysis on what other states have allowed, and other states have essentially said that employers can sign a waiver one time that they can revoke. In other words, so for employees who are scheduled to work a shift where they don't get a meal break, they could waive that meal, and then they have to notify you that they're revoking that waiver. And certainly we think that would be in compliance because it's clear that we're allowing them to do so and it's their choice. But if they're going to revoke their waiver, they have to let us know. But as long as the language is clear in the waiver that they're allowed to take a meal and they're waiving it, I think you're going to be sufficient. So
Um, okay, so one person, Angela, has asked, could you provide us with a waiver, an example of a waiver?
yeah, I would ask that they reach out to us,
Okay.
just so we know what the specific issues are that they're trying to address. I always get concerned when folks are trying to do a one size fits all catch.
Okay, so everyone, if you would like an example, reach out to Tom and we'll of course provide his email. We're going to provide this recording and we'll provide his email address as well. Um, Aaron did provide some information from Mindali, says that they provide a fax sheet FAQ that's very helpful. Um, and then he listed sample scenarios of hours worked. So he made that recommendation.
Yeah,
Um,
and there's a great question that's raised. Do we have to prove that they took their regular break? And I think that is just, it's a great question. And my advice is yes, I would make sure that there's some type of documentation that establishes that the employee took the break or that they know to notify you if they were not allowed to take the break. And I think, again, it's going to be how you handle it is going to be a business by business decision. Some employers are incorporating into their payroll system. If it's electronic, there's ways to program your electronic timekeeping system so that when they're recording their time, that they actually have to answer the question. I was allowed to take my breaks today, right? Some folks are making sure that if it is a handwritten recording of time for the day, that employees are signing off that they took their rest breaks during the course of the day. My question is, if you don't document the fact that they were taking breaks, ultimately what I foresee is a plaintiff's counsel challenging the company and saying you did not allow employees to take their breaks and you're not going to have any documentation to prove otherwise. And I would rather that employers are proactive in showing that the employees actually took the break or were allowed to take the break, and being able to show that on a daily basis versus not changing how your payroll practices look today. Other questions? I know this has been kind of a hot topic within the print industry. So other questions that you have?
I have a while back, I know that one of our members sort of sent some questions, um, and you may have answered them, but maybe I'll go. through the questions that they have because they said that they're getting different interpretations between HR and how production feels. And you may have answered some of these, but can employees volunteer? We talked about the waive all breaks, and you said that we might be able to, if they connect with you, they may be able to get a waiver from you. Can employees skip their lunch break, or is that required regardless of preference? I think you covered that.
Yeah, employees certainly can waive their right to a meal break.
Okay. For 12, for a 12-hour weekend shift, are two 30-minute unpaid meals required, or would one meal plus paid breaks be sufficient?
Yeah, and that's sufficient. And that's actually addressed in the Dolly FAQs.
Okay. For 12-hour weekend shifts, are we required to provide three breaks and one lunch, and must they be separated, not combined?
Yeah, we'd have to go through the schedule, and that's where it gets a little difficult with regard to how to describe the various schedules. But you do have to provide a rest break within every 4 consecutive hours, plus provide a meal break every provide a meal break if they work 6 or more consecutive hours. Yeah, great question. I see Aaron. Aaron, thank you for raising this question because it's something I wanted to address in the webinar. And Aaron's question was, does the law specify a difference between exempt and non-exempt? And the answer is yes, it does. So thank you for raising that, Aaron. So with regard to the meal and rest break periods, under Chapter 177, which addresses meal and rest breaks, there are exemptions for certain groups of employees. And one of them that is exempt are what are referred to as salaried exempt employees from the rest and meal break periods. And the statute specifically defines who is exempt from a salaried exempt standpoint. But professional, I got to think through this: executive, administrative, and I think professional are the exemptions. I'd have to double check that. But there are 14 different exceptions for purposes of this group. The, the exceptions really would come into two places. One would be salaried exempt employees are likely exempt. And then two, to the extent that you have DOT covered drivers that work for you and they are working interstate, they would be exempt from coverage as well, as long as they're subject to the authority set by the DOT administrator. But those are two of the 14 exemptions. The others aren't going to apply in this scenario. Great question, Aaron. Thanks for raising that.
Did you see the question from Brittany that said, should employees complete an attestation at the end of shift confirming breaks were offered?
Yeah, that's so Brittany, that's one of those comments that I was making, that I think that is ideal to have them sign such a document at the end of their shift, and that could be part of the payroll system, right? I was allowed to take a rest break every 4 consecutive hours, and I either took that rest break or waived it and have them sign off on that. But yes, I think that is a safe way to protect the company from a future wage and hour claim.
Yeah, I think that was kind of the same question Angela asked. Can we have employees sign a form that they get their break at a certain time daily? And if they do not, they are responsible for notifying their supervisor.
Yeah, same thing. And that's, with regard to the rest and meal break law, one thing I want to just remind everyone is obviously we have the paid family medical leave that takes effect January 1st as well. And hopefully everybody is updating their employee handbooks and their policies and procedures to address PFML. But in addition, your employee handbooks should be updated as well to address the changes in the meal and rest break periods. And my advice has been that when you're updating your handbook, you address the rest and meal break periods and also incorporate that language that is being raised by the attendee, which is put into that policy in your handbook that if they were not allowed a rest or meal period, that they need to notify you so that we can take appropriate action. And that's going to beg the question, which is, what if we learn that an employee was not given a rest period within the 4 consecutive hours, or they weren't allowed a meal after working 6 consecutive hours or longer? What do we do in that scenario? And I think the safest bet is that you essentially correct it by paying the person for the time that they were denied, as well as the liquidated damages for what would be the penalty for failing to give them that time. I wouldn't look the other way. I think if you look the other way on that mistake, you're just inviting a plaintiff's lawyer to bring a wage and hour claim against you. By the way, I do think we're going to get some plaintiff side wage and hour attorneys from California setting up offices here in Minnesota in light of the changes in the law. It's been a huge issue in California. Any other questions?
I had one more ask, or um someone asked, or how should we address employee concerns about losing pay when required to take unpaid breaks?
Well, that's kind of a loaded question in the sense of, are you, so the law is you have to allow them to take a meal period. And it sounds like the question is assuming you have to mandate that they take the meal period. And I suspect that there are some businesses that have just decided, you know what, we're going to mandate that you take that meal period just because we're not going to go down the path of waiving. And if that is the case, then I think you just have to be frank with the employee and say, look, the law changed and the law says we have to allow you to take a 30-minute meal period if you're working 6 or more consecutive hours, and that's what we're doing. That's what the law provides, and we're allowing you to do so. And then if the employee says, well, I would like to work through my meal, then the business is going to have to decide, are we going to allow that to happen or not? I suspect there are some of you that have just made the decision, you know what? Everybody's going to take a meal. And it may be because you feel very strongly about the fact that they should be taking meals, and it may be because you just want to avoid any potential exposure with regard to an employee later claiming that they were not allowed that meal.
I think that's all the questions that I had received via email.
Okay.
Um, Once again, this presentation has been recorded, so we are going to share it with all of you. We will share Tom's email address so you can reach out to him to talk about the waiver and for individually for your company, as well as you can talk to him about updating your handbooks if you haven't done so as well. I don't think I see any other questions on the chat. You can also blurt them out right here if you'd like to take yourself on mute. But if not, I think we're covered. We can stick around for a minute or so if you don't drop off the call, if you want to ask a question. Um, or ask a question now. But like I said, I think we've covered all the questions unless there's more. Um,
And Chris, just if we're going to segue into a different topic, just a very quick reminder, I'm sure everybody is on top of this, but do not forget the December 1st deadline with regard to getting your individual notices out for paid family medical leave and making sure that you get your posters up for paid family medical leave. As I assume everybody knows, the paid leave program has developed the model templates for you to use to provide individual notice to your employees on PFML. Keep in mind that there are different individual notices that you can use. One is if you're going through the state. One is if you're going through an equivalent plan. So make sure you're using the right notice when you're notifying employees individually. And a common question has been, well, can we just email that out? And the law essentially says you have to be able to show that the employees received the notice. And ideally, you're having them sign off that they received the notice. You could do the automatic reply if through emails. You could do it through your payroll system to have them acknowledge that they received it, but you will ultimately have to show that they actually received the individual notice. But hopefully, everybody's well ahead of the game at this point.
well, this ends our presentation. Thank you, Tom Revnew, for providing us insight onto this new law that will happen in January. As stated, we will stick around until y'all drop from the call. So if there are people that want to ask a question at the end, we'll be here for at least another minute or two to see if that happens.
Thanks, everyone.
Thank you.